Hi, everybody. Welcome to American United member briefing for the Kennedy v. Bremerton case. Thank you so much for joining us. We'll get started here in just a couple of minutes, so we give folks a chance to join. A few reminders before we get started. You should see that we have ASL interpretation on the screen. You can also pin that so that if you want to keep it in one spot. We also should have closed captioning turned on. Along the bottom of your screen, you should see 3 dots that say more, and you can turn on subtitle. And for questions, we're going to be, looks like somebody said they can't hear. If folks are unable to hear me right now, well, I guess I can't really say that. Okay, we've got some other folks saying they can hear, so I appreciate that. This is being recorded and we provided to everyone. We're going to use the Q&A function for any questions. So again, along the bottom of your screen, click on Q&A or click the 3 dots if you don't see it where it says more, and you'll see it there in the list of tools. Again, we're going to give it a couple of minutes. We don't use the chat during this. It just gets a little bit too overwhelming. So again, as a reminder, use the Q&A for your questions. We will be putting some links and information in the chat as we go forward. And again, welcome. We're going to give it just a couple minutes. We've got quite a few hundred people that have signed up for this, and the room is still filling up. So thank you again for being here. All right. Again, welcome everyone. Thank you so much for being here. We're going to give it just a minute or so more for folks to finish joining. Again, we will not be using the chat or the hand raise feature as we normally don't. If you have any questions, you can use the Q&A function. We'll be going over how to use that in just a minute. We're going to give it about 30 more seconds before we get started. Okay, we're going to go ahead and start. Good evening or good afternoon, wherever you're joining us from. My name is Brian Silva. I use he, him pronouns, and I'm the Vice President of Outreach and Engagement here at Americans United for Separation of Church and State. And it is my pleasure to welcome you to join us this evening. A couple of housekeeping items before we get started. You should see that we do have ASL interpretation on your screen. If you're having any issues with that, please feel free to put something into the chat. We also have closed captioning, which should be displaying on the bottom of your screen. If not, along the bottom of your screen, there should be a button called subtitle, or you'll see 3 dots that say more. And when you click on that, you'll see the subtitles, which you can turn on. Also along the bottom or in that more section is the Q&A function. That is how we'll be collecting and answering questions tonight. Unfortunately, we cannot use the chat or the hand raise for questions. So please feel free to put your questions in there at any point during the briefing. We will get to as many questions as we possibly can. I think in our last briefing, we got to almost 40 questions. We'll combine some if they are similar, and we'll do the best that we can to get to them. Also, this is being recorded, and a link to it will be provided to everyone who RSVP'd tomorrow afternoon when we get to get it uploaded to our YouTube channel. With that, for those of you that are new to Americans United, We are the only organization dedicated solely to defending the separation of church and state. We are the shield protecting the foundational American principle of freedom of religion, including the right to believe or not for all. So before I introduce our panel, I just want to acknowledge it's been a rough couple of weeks. It's been a rough while with this court, but especially the past few weeks. The decision in Carson v. Macon, which was a serious blow to public schools and religious freedom. The decision on Friday in the Dobbs case, taking away the constitutional right to an abortion, and the hat tip that also said that they are coming for other personal privacy rights, like the right to contraception, the right to marry the person you love, regardless of gender or sexual orientation, and the right to consenting personal relationships between people of the same sex as well. It just shows the further erosion. So I just want to acknowledge that folks are probably feeling a lot of different things today, and that's okay. Encourage you to make sure you're taking care of yourself, reaching out to others. We're going to be in this fight for the long haul, and we need folks to be taking care of themselves first so they can join AU to continue to fight for the many months and years ahead. With that being said, I would like to introduce to you the amazing team that is going to be on that journey fighting with you, our panelists this evening. So we'll ask them to turn their videos on now so you can see their bright and smiling faces. It's my pleasure to introduce Rachel Lazar, President and CEO of Americans United, Gabi Hybel, the Madison Legal Fellow here at AU and a member of our legal staff and team, and the Reverend Doug Avilesbernal, who's the Executive Minister of the American Baptist Church and our newest member of Americans United's Faith Advisory Council. So welcome everyone. Thank you so much for being here on a tough day, after a tough week, after a tough couple of weeks. I think everyone's really excited to hear what we have to say. So Rachel, I'm going to hand it over to you to start us off with some opening remarks.
Thanks, Brian, and great to be with everybody. I think we can all agree that during rough times, being with each other is the best place to be. So I'm really happy to be here with you all, with the AU family. As we know, yesterday, the conservative bloc on the Supreme Court triggered what we are calling the greatest loss of religious freedom in a generation. And they did that when they permitted an agent of the state to impose his personal religious views and practices on other people's children, on students in our public schools and their families. And we know that this assault was orchestrated by a $1 billion shadow network that somehow succeeded in spinning what the lower court George W. Bush appointed judge called a deceitful narrative, all the way up to and through the Supreme Court. Religious freedom is not the right to impose your religious beliefs on other people through your government job. Religious freedom is a shield that protects the rights of all students to believe as they choose. Until now. Religious freedom is supposed to belong to all of us and not just those who hold power. But that just isn't the case when the Roberts Court is ruling in support of religion 85% of the time, and it's always in support of far-right, conservative Christian extremists. And what's worse is that this network of religious extremists and their lawmaker allies are far from done, right? It's really scary to think about what might be coming next. The dissent said all of our rights are hanging in the balance. The dissent that was Justice Sotomayor, joined by Justices Breyer and Kagan. And there really is so much more to come. Brian referenced the, Thomas dissent that said the quiet thing and called out Griswold and Obergefell and Lawrence, sexual intimacy and the right to sexual intimacy in your own home is on the line. Same-sex marriage could be on the line. The right to contraception for married people is on the line. And up until the Dobbs decision last week and what came down yesterday, I was one of those people who might have said it's a risk, but I don't feel like it's necessarily a very high risk. But personally, and I think probably many of you would agree, I just don't feel like I can say that anymore, which is truly frightening. I think what we're witnessing from this Supreme Court tells us one thing for sure, which is that all of our rights are not safe. What was absent from this opinion yesterday was any mention of the students that felt pressured and who were made to feel like outsiders because the coach was pressuring everyone to pray in this one specific style and way. You know, the court didn't talk about the atheist student that really wants playtime and was worried about, you know, not joining prayer because he wanted to play. The court didn't talk about the Jewish student or the Muslim student or the Buddhist student that was worried about recommendations for a college scholarship or for college, and just felt like they weren't able to not join in, you know. And interestingly, after the decision came down, my own brother-in-law, he texted me and he said that he grew up Jewish in Texas and that he couldn't stand the fact that when he played football in high school, he had to say the Lord's Prayer every time. So I think what we're witnessing from this court is a court that does not show empathy for those who don't have power and instead bestows more power upon those who haven't. And I think we saw that as well in the Dobbs abortion decision, where the court didn't talk about the plight of pregnant women, of lower income women, of the many Black and brown women and Indigenous women and folks that already have a harder time accessing healthcare, you know, who might not be able to access abortion anymore. The court didn't mention those folks. In the Carson v. Macon case, the court didn't talk about the taxpayers who are now going to be forced to fund religious schools that teach that Islam is a sin against God, and they could be Muslim taxpayers. You know, the court didn't reference the LGBTQ and taxpayers who are for LGBTQ equality and straight allies who are offended to have their tax dollars go towards funding schools that force students that come out as LGBTQ to go through conversion therapy and otherwise expel these students if they don't renounce their true identities. So this is where we seem to be right now, and our Supreme Court is at its worst. And I think one thing is clear, which is that the work of Americans United has never been more needed and more important. We're just so grateful that we all have each other at this moment, and for your incredible, for our smart, loyal, invested supporters, you all, that you've made us strong for 75 years, and boy, do we have a lot of work to do. So we have a lot to talk about. Brian, I'll pass it back to you and let's get into it.
All right, thanks, Rachel. So Gabi, let's start this off. So before we dive in deep, just can you briefly set out the real facts in the case? And this is important because we know that this billion-dollar shadow network who was funding our opposition worked overtime to spread a false set of facts in the press, in the public, and in the court. I just was reading on Monday, CBS News of all places posted Supreme Court sides with football coach who lost his job for praying after games, which he didn't lose his job and is so just blatantly false. So give us the real facts.
Yes, absolutely. Hi, it's so great to be with all of you. So like Rachel said, like Brian said, the court really bought into a deceitful narrative from the other side, but here's what really happened in this case. Coach Kennedy was a coach at a public high school in Bremerton, Washington, and for several years, he led his football players in prayer at the end of each game. When the school district found out, they reached out to him and they said, "We'd like you to please stop praying with students. We'd love to find an accommodation for you where you can pray privately, but we're worried that when you pray with students at the end of games on the 50-yard line in front of the entire crowd, that looks like a violation of the Establishment Clause, and we're really worried that students might feel alienated if they don't participate in that prayer. Kennedy refused. Instead, he went and he hired some lawyers who wrote a letter to the district and said, Kennedy must be allowed to continue praying with students. Meanwhile, after his lawyers sent that letter to the district, Kennedy went on a media tour. He told the media that he did these prayers with students because these prayers were how he made his players better people. He also said that he was going to continue praying with students on the 50-yard line. Unsurprisingly, he followed through with that. At the homecoming game, at the end of the game, he went to the 50-yard line, he kneeled down, and he started praying. And very quickly, a swarm of people surrounded him. These were students, players, fans, media, elected officials, families. They all swarmed the field in order to join the prayer. And in the process, they knocked over students in the marching band. It created a huge mess. Meanwhile, the administration was getting hate mail, death threats from the public who were on Kennedy's side and wanted the district to just let him keep praying with students. It got so bad that the head coach worried that he might be shot from the crowd. A Satanist group showed up, also tried to go onto the field and practice their religion. But despite all of this, the district kept trying to work with Kennedy. They said, we want to find an accommodation for you. We want to engage in the interactive process of finding something that works for all of us. Kennedy refused. He continued praying at games. He continued being joined by people from the public, elected officials, and eventually it reached a point where the district had to put him on paid administrative leave. After the district did that, students and families reached out and said, thank you so much. Thank you for addressing the situation. Thank you for ending an awkward situation where I felt like I had to participate in prayer in order to get playing time. But it doesn't end there. Kennedy brought it to court. It went up and down in the courts for many years until it got to the Supreme Court. And unfortunately, although not particularly surprisingly, the majority, written by Justice Gorsuch, completely bought into this narrative. Justice Gorsuch described the prayer as personal, as private, as quiet. Luckily, we had Justice Sotomayor writing in dissent and including a picture of what actually happened, which I think we can put up on the screen. Right, so this is what happened. This is not a personal and private prayer, but it doesn't matter that Justice Sotomayor pointed that out. It doesn't matter that Justice Sotomayor put it in her dissent and showed that the majority wasn't telling the truth. Justice Gorsuch just ran with it, continued describing this as personal and private. And I just want to highlight this partially because as much as we're seeing the Supreme Court really attack precedent right now, the fact that the dissent and the majority disagreed so much about the facts is actually quite unusual. And I think it's a little bit foreboding of what's to come from this court, where we can't even agree on what facts are true and what facts are false.
Great, thanks, Gabby. I know we have a lot of questions in here about folks asking about, well, didn't they say this? And this is what we want to, really be expressing to folks, like these arguments were made, photographic evidence, and it was ignored. We're going to dig into that a little bit more as we go in. So, Gabby, before we talk about what they specifically said before this decision in Kennedy v. Bremerton, what were the rules and precedents that guided government officials, like a public school teacher or coach, in expressing their religious beliefs on the job, like Coach Kennedy was doing? Because there were rules beforehand. So tell us about that.
Yes, there absolutely were rules. I think it's important to remember Coach Kennedy is a public employee. And so that creates a little bit of tension. And in order to deal with that tension of government employees' First Amendment rights and also a public employer's interest in regulating speech when necessary and having an efficient workplace, courts have come up with a test it's a balancing test. You look at the government's interest in regulating the speech and the public employee's interest in that specific speech. And here, the interests that came into tension were Kennedy's interest, as he describes them, in his free exercise right to pray at the 50-yard line with students at the end of games, and his free speech right to pray at the 50-yard line at the end of games with students. On the other side is the district's interest in not violating the Establishment Clause and in protecting the free exercise rights of its students. And based on that precedent, based on that balancing test and what the Supreme Court has said about the Establishment Clause, about the Free Exercise Clause, it really looked like it should have gone in the district's favor. It looked like the district's interests absolutely outweighed Kennedy's. Here's what the court has previously said when evaluating Establishment Clause cases and when deciding whether or not something violates the Establishment Clause. It looks at a lot of different factors. It looks at, does this government action, so here, Kennedy's prayer, does that look like a government endorsement of religion? The district argued, yes, it's a coach in his uniform, surrounded by his players at the 50-yard line in the middle of the field, praying with his students. That looks like the government's endorsing religion. Another thing that courts have previously looked at when deciding whether or not something's an Establishment Clause violation is, does this coerce people? Would a student who's on this team feel like they had to participate in order to get playing time, in order to get a good letter of recommendation, in order to get in the coach's good graces? And finally, another thing that the court has looked at when considering the Establishment Clause is something that is called the Lemon test. It looks at the purpose, it looks at the effects, and it looks at whether or not government and religion are getting too entangled. This has been a test that's been around for a while, although it's been critiqued by conservatives on the court for a very, very long time. All of those really weigh in the district's interest. It looked like an Establishment Clause violation. It was an Establishment Clause violation when Kennedy put pressure on students to pray with him at the 50-yard line. And also, it's not just the Establishment Clause that the district had going for it. It also was worried about violating the free exercise rights of its students. The court for a very long time has said that parents and families have a free exercise interest in controlling the religious education of their own children, in determining that religious education, and making sure that the message that they hear in Sunday school isn't contradicted by a different religious message when they go into public school on Monday morning. Here, that's absolutely what was happening when students were showing up to football games and then being expected to participate in a group prayer at the end of games. That was a violation of their and their families' free exercise rights. On the other side of that, we have Kennedy's First Amendment interest in speaking and praying on the job. We're not arguing, and we never argued that his interests are non-existent, but simply that they're not absolute when he is serving as a coach and when he is supervising students, when he is mentoring them, when he is leading them as their coach. He has to be respectful of their constitutional rights as well, and his rights do not trample over the rights of his students. So to bring it all together, the law is clear that the district's interest in protecting its students' free exercise rights and in avoiding an Establishment Clause violation outweighed Kennedy's interest in praying at the 50-yard line at the end of games with students. He doesn't lose all of his constitutional rights at work, but he doesn't have the right to pressure students to pray with him.
Great, thank you. And Reverend Avilesbernal, we've had quite a few questions about folks asking, the Bremerton and wider local community, which you and you have a local church that is there as well, and you were a part of a group of faith leaders in that community that really stepped up to say to the Supreme Court that this is a separation of church and state issue, and that the rights of people of all beliefs needed to be protected, especially students. Did the people in the community also have a hard time distinguishing what the facts were and what was being spun by the opposition? Like, was there a sense there that people felt Christians were under attack because the district didn't want the prayers to go forward, or that it would be coercive to students?
No, this is what's complicated for us in Washington, is that we thought this was a settled matter according to what the judgments from all the courts that it went to had come down. Everyone in Bremerton is in agreement that this was settled, mostly because his prayers were neither private nor by himself. They were causing a lot of disruption, even violence at the football games. It was clear that he was trying to make a point rather than have a faith moment himself. So when the first decision from the court came down that he, and he was suspended and this was over, then everyone there, I mean, it's tough to say everyone, I'm sure there are those who disagree, but overall majority were happy that making a show of what should be your personal prayer was neither adequate nor legal. So the confusion for the space in Bremerton is, why are all these people from outside coming to revive something we thought was settled? And that's the difficulty now.
Yeah. So we now have a decision that came out Monday. Gabi, can you talk us through what was in the decision, what was the majority's thinking, what they said, but also the forceful dissent of the minority? And I know there's a lot of questions in here, and I know from your notes you're going to hit on quite a few of them. So folks, we'll get to a bunch of them right now.
Yeah, so the majority didn't decide explicitly whether to apply the balancing test that we advocated for, or whether to apply a much tougher test that Kennedy asked for. Instead, the majority said the district doesn't satisfy either test. And how did it do that? First, it did that by getting rid of a ton of precedent. So that precedent I spoke about a few minutes ago about looking at whether or not a government action endorses religion, whether or not it gets entangled with religion, whether or not the purpose and the effect advance religion, all of that is gone. Instead, the court said, we look at history and we look at tradition. I'll note that Justice Gorsuch, in a footnote, acknowledged that he doesn't know what that means, that he doesn't actually have any guidance for how to apply that test. All he said is coercion probably violates, or coercion does violate the Establishment Clause, even under this history and tradition test. But there's a concern that he maybe undermines how much coercion actually matters. He says, when it's explicit, when it's a requirement, that's coercive. But here, under the facts that Justice Gorsuch adopted from the other side, the facts that he made up, he said this isn't coercive. There's maybe a silver lining to that. If he had said that what actually happened here, where Kennedy had this long practice of praying with students, where students said that they came forward and said that they felt pressure to participate, if he had said that that wasn't coercive, that would be a huge, huge blow. Instead, he said that this fictional thing where Kennedy prays privately, on his own, quietly, silently, that's not coercive. So I think the silver lining that I'm trying to pull from this case right now, at a time when it's really, really hard to find silver linings, is that because he based his decision on these fictional facts, there's a hope that it doesn't expand to every single circumstance. It just expands to the circumstances that he described and that he adopted from what Kennedy put forward. But it does mean that a whole lot of law is gone. So endorsement is gone, Lemon is gone. These are tests that we at AU think are really important for protecting religious liberty for everyone. And in its place is a history and tradition test. This is a fuzzy test, and it leaves a lot of space for justices who are not historians, who are not trained as historians, and often don't do a very good job of interpreting history, to come in and say, this is my view of what history means, and that's how I'm going to interpret the Establishment Clause, or religious liberty in general. And I think Sotomayor's dissent, she does a wonderful job in a lot of areas, but I think something that she does really well is highlighting why this history and tradition test is frightening. And I'm going to quote from her. She says, the effects of the majority's new rule could be profound. The problem with elevating history and tradition over purpose and precedent are well documented. And then she cites two cases from last week. She cites to Dobbs, which overturned Roe v. Wade, and she cites to Bruin, which is the case that said that New York's gun regulations were not constitutional. Those were both based on history type tests and have led to really disastrous outcomes for our bodily autonomy, for our safety, for our well-being as a society. And now that frightening test is similarly being applied in this context, in the religious liberty context. So we're seeing this across the board, and it's still, the court left open a lot of questions. And so, with this court, it's good when things are left open. It's good when things are not definitive, because it means that there's space for, hopefully with a different court in the future, to make things a little bit better. But yesterday's opinion was pretty gut-wrenching for all of us. It really wiped out a lot of good law that has done a lot of good to protect all of our religious liberty and to protect students in particular.
Thanks, Gabi. And thanks, Arturo, for your question, and many of you about some of the other precedents like Santa Fe, like Lee, and as we mentioned, talking about Lemon. Gabi, we keep getting the same question over and over again, and I'm just going to ask it again just so we can be very clear. The majority who wrote this opinion ignored the facts of the case. That is correct.
Yes, absolutely.
Yeah.
I don't have Sotomayor's quote right in front of me, but she calls it out explicitly. She includes those pictures to make it obvious to anybody who just glances at the case. the majority ignored the facts of the case completely.
Yeah.
And it did
No,
so because Kennedy ignored the facts of the case as well.
Yeah, exactly. So I know, Frank, you had asked about how did Gorsuch ignore this, and other folks said, why didn't they talk about, being private prayer or being offered, alternatives? And that's been part of the whole issue with this, is that all of those things did happen. And so the court literally ignored them. And that brings us to this next question, Rachel, and looking forward, when our country's highest court has become so politicized to the point of ignoring the rule of law, a lot of folks here who believe in AU's mission are wondering, how does that affect our work moving forward to defend this critical constitutional right that we've been doing for 75 years now?
Yeah, it's a good question. But there's so much work to do. We have a lot of answers. So one answer is we need a long-term legal strategy. And I do use the word legal there first and foremost. I'm not saying it's more important than other strategies, but we can't give up on 1/3 of our system, right? The judicial branch entirely. For example, right now, religious extremists are going to be emboldened to be bringing all sorts of lawsuits to try to get them to go all the way up to the Supreme Court. And they need good people defending, right? So AU is really important in being able to try to minimize the losses, right? And that's just one thing. We are playing the long game though. And I've talked about this in some of my columns and weekend review, but I'll say it again. We actually have founded a legal academy at AU. We just piloted it this year. And it is sort of a counterpart to what the Federalist Society is doing. We brought together 60 law students who are the next generation of leaders in the public interest sphere. And we taught them strategy of what to do when the courts are conservative, and philosophy. What do you do with originalism? Do you throw it back at them? And use it on our side? Do you ignore it? And also hard litigating skills. But more than anything, we formed community among them with each other, and also linking them to my generation on up of leaders. So that, I think, is really important to play that long game. We also need to be able to use the courts to build our movement, right? And to be able to build the diversity and grow the number of people that are committed and understand the importance of church-state separation. That's why right now we are preparing, it'll take us a minute, but we're preparing to bring our own litigation challenging abortion bans from a religious freedom point of view. And these are complex things to figure out, right? When you bring these cases, that you may not always prevail. And so then part of the goal is to minimize the damage. But the bonuses are you get to reshape the narrative, you get to expose the hypocrisy and say religious freedom doesn't just belong to far-right Christian extremists in this country. It belongs to all of us, right? And you get to grow the movement and have people, you all get it, but have everybody else awaken to how important church-state separation is to so much of what they hold dear. And so I think it is fair to say that we are focused on the next generation, right? Who can help us protect this right. We're playing the long game. We're focused on growing our movement. We're focused on reaching faith leaders. And, we're so proud to have Reverend Avilesbernal with us now on our Faith Advisory Council. He is such a stellar representative of the church-state separation cause. And, we are focused on our Faith Leaders United list. We are focused ruthlessly on our visibility. And I hope that you've seen us everywhere, at least making lemonade from lemons of these losses that we've been undergoing, and out in the media, shaping the narrative, talking about church-state separation and what it's really about. So there's tons for us to do. And we know that the other side didn't win. They didn't reverse Roe v. Wade. They didn't get to this place where they're inviting prayer into our public schools through just one blow. It was like death from 1,000 cuts and slow and methodical building, and their donors didn't ever give up either, right? Everybody stuck with it, and here we are. So we are committed to doing the same on our side, and we certainly have a lot of plans.
Reverend Avilesbernal, one of the goals of the Faith Advisory Council that you're on with AU, and again, so appreciative, is that, you know, to counter this narrative that first, you know, somehow people of faith and religion overwhelmingly are against the separation of church and state, which we know is absolutely false. So, you know, some Christian leaders, especially with this decision, are trying to say, oh, this is a win for all Christians or all people of faith. But, you know, we know so many people of faith do support keeping church and state separate because it protects, you know, them. Can you talk about how you and other faith leaders, you know, feel about the decision in this case, and maybe how folks on the call could engage with people of faith who don't understand why this is problematic? You know, sometimes folks are like, you know, what's the harm in a simple prayer?
Yeah, well, the what saddens me is that it seems a part of it has been the result of complacency. You know, some of us, I just thought, well, it is the law. There's no way they would undo it. But what we've learned, and what we were afraid within the Christian family, is that those who have ascended to the court have very little regard for current law or what's happened before. Their understanding, sadly, is that they answered to a higher law, that our country's laws are beneath it, and so president doesn't really matter, etc. What we're working on then is to remind them that higher law they like to ascribe to actually says the opposite of what they're doing. The entirety is, particularly on the Christian side, you know, the Christian conservative side is deeply rooted in what they call their relationship with Jesus. And one of the things that we're going to be doing then is using those Christian scriptures to highlight for them how wrong they are and how misguided they have been. Fear has been nurtured in them, and it's such an insular community. That's the problem. It's such an insular community that they've been taught, like a cult, that anything that doesn't come from their pastor is not true, unless the pastor tells them that other person is appropriate. So getting through into that cult perspective is some of the things that we're strategizing about with regards to these discussions, because clearly telling them they are wrong outright just sort of makes them feel like there's this ethos within that side of our family that says that if people are against you, it means you're doing the right thing, right? So in essence, it encourages them to hear that they're wrong. What we would like to say is that forget you're wrong or forget other people, not because they're not important, but this is just to speak to a very narrow spectrum, right? To say to them, you are sinning by what you're doing, and you're sinning against Jesus. And this is why. Because one of the beauties of this argument is that we have very little information about Jesus speaking on a specific issue in a specific matter, you know, so that gives a lot of leeway. But in this particular situation, for those who believe that the New Testament includes Jesus's word, it is clear Jesus was absolutely clear that Coach Kennedy was wrong. You know, and especially he was absolutely clear in there are 4 gospels. Of those 4 gospels, the Matthew gospel is the one that's more legalistic, the one that's closer to the law, as it were. It is in that one then that we hear Jesus be very clear that public prayer, in order to be seen, is a sin. There's no ambiguity. There's no room for interpretation. The words from the original Koine Greek through the translations into now are all very clear that it is a sin to pray in order to be seen. That's at the core of our conversations with our brothers and sisters on the very conservative side, to say to them, your faith does not depend on being used for political reasons. You know, and then so to sort of wrap that up is to say that it is clear that Jesus avoided political power, political cities, and the influence that came with that. And the world was, according to Christians, the world was transformed without any of that. So our journey with this conservative side is going to be around sin, to say we are concerned because you're actively sinning against Jesus. And you know, it sounds like semantics, but these are words that are very important within the conservative Christian context. And the sad thing, and I'll close with this, the sad thing has been that a lot of our arguments within have been, why are you in the cult of Trump? And that sort of just emboldens them, because they sort of say that it doesn't matter what he's like, he's just the tool that God chose to bring all that God wanted to us. What we want to say in response to that is actually, is the sin of accepting someone who's lying their way to a position of power that brought all of this on us. And if you're interested in that, this will be early on in Judges, around the chapter 2 of the Hebrew scriptures, which they call the Old Testament, right? In Judges, God is clear. He says, if you are asking me for a king, I will give you one, but you will pay the price for it. And so there's a lot of, what I would say in closing is that when we engage with this side of the world, we need to make sure that we know the scriptures that are foundational for them and draw from those scriptures, which I think support this, to say to them that in fact they are sinning against God by supporting what they're supporting. There's more detail about that, but yeah.
And I know a few folks have asked about, is there a bit of a slippery slope sometimes about, having these types of conversations. One of our guests, Helen, was asking about that and how laws shouldn't be based on any religion. And I think what's beautiful about the fact and this is that when we're going to start to do education, reach people, start to bring people into our corner, we have to talk to them in the language that they speak and that they understand. And when you're talking to folks who are very conservative Christian and that is their world, we have to talk the language that they speak. And this type of conversation, it's not how we would talk to atheist groups or maybe other groups, but it is how we're going to talk to people who don't believe what we believe about church-state separation and do it in a way that can actually move them, which I think is a fantastic thing.
If I could just say, I'm sorry, one sentence. Baptists only exist in this country because people in power did a separation of church and state. Because when church and state were one, Baptists were ostracized, burned, drowned. So the reason we exist is because of separation of church and state. So we hold firmly to that line, and it must be protected by every generation.
100%. Gabi, one of the replies, there's a lot of questions in here about, well, just wait till the Church of Satan or Wiccans or Muslim groups, file their same lawsuit. And, I know we've talked internally, especially in the legal team, there's a lot of problems with that because of the way that this decision, this court is. So what do you think about those ideas?
Look, I completely understand the temptation of pointing out the hypocrisy of the Supreme Court's case by bringing these sorts of challenges, but that is based on an assumption that this court is acting in good faith when it just frankly is not. I mean, we have seen the way that it treats Coach Kennedy versus the way it treated students of minority faiths who were on his team, who felt pressure to pray and said, doesn't matter, that's not coercion. We saw it also in Carson, which came out last week. And that's the case that Rachel was talking about earlier, in which the court held that if a state has a voucher program, that voucher program also has to fund religious schools, even though that means that taxpayers are going to be funding religious education, even education that's completely contrary to their own beliefs. So it means a Muslim taxpayer would have to fund education that teaches that Islam is contrary to God's word. That's not religious freedom, but the Supreme Court ignores that when it's considering religious freedom of groups that are not Christians, and particularly conservative Christians. And so I completely understand the desire to say, let's bring a case representing the Church of Satan. Let's bring a case representing the groups that this court doesn't find as sympathetic. But we know how the court is going to look at those cases because it's shown us. It showed us in Bremerton, it showed us in Carson, and it's shown us throughout its recent cases.
Yeah, and I'll just add two things, which is number one, the $1 billion shadow network wouldn't be there for the Muslim coach, right? So like the odds that this case sort of gets to the Supreme Court and is taken on, by such a profoundly rich network is nil, basically. So that's point number one. And point number two is, think about it too. If the court's using this history and tradition test, like they will also probably say that history and tradition is about Christianity, or it's one step away from saying that, right? I mean, these are the folks who claim that America is a Christian nation, right? And we've evolved, we've always had some diversity, and there were the religions of the natives who were here on the land, and other religions in our country, even different, obviously different forms of Christianity, Reverend Avilesbernal, but also to your point, but think about the history and tradition argument. Like, none of our evolution towards being a more diverse people fits with the history and tradition test.
And Rachel, a lot of folks are asking, can you just give like the quick, 30, what is the $1 billion shadow network? Because some folks are just joining us for the first time and have asked to expand a little bit more about, who and what that is.
Sure. So the $1 billion shadow network are, I think, most visible if you look at who submitted the friend of the court briefs on the side of Coach Kennedy in this case. And they're like the who's who of extremists in this country. But the reason that we call them $1 billion shadow network is we actually added up the annual revenue of each of the groups that were there, about 50 of them, and it totals over $1 billion. Right. And that's something like that we have to bear in mind on our side, that the other side is just better funded, right? And they've been better funded for a long time. We're talking about the Koch brothers. We're talking about the DeVosses. We're talking about 5 Trump alumni who started their own organizations. We're talking about the organizations that fight reproductive freedom. And the guy who was the architect of the Texas abortion ban. We're talking about the groups that are advancing anti-Muslim bigotry. We're talking about like the group that brought the Masterpiece Cake Shop case, the anti-LGBTQ groups. We're talking about basically like a well-funded community that is fighting any social progress, right? And trying to maintain sort of the status quo of where power structures are, which is another point I think to make. And I was going to make this in the end, but I'll just make it now, which is we have to, it occurred to me the other day. I was finding a little bit of peace in yoga, actually, talking about taking care of ourselves, trying to, in a quiet space. I'm feeling pretty devastated, in this moment as a woman, as a religious minority, as someone who has children and worries about the future of our country. And I was thinking about it, how do we claw our way out of this moment? And one of the answers has got to be us uniting together, that we're uniting together, all folks that are part of marginalized communities. And frankly, that's all of us in one way or another, that we're there for each other and we're supporting each other. And I think that's one of the things that Americans United does best in this very divided moment in our nation. We are bringing together people of faith and atheists, people from California and people from Louisiana. We are bringing folks together because the folks who we're bringing together, which is the majority in our country, are very concerned about the state of our democracy and understand how foundational church-state separation is to it. So the $1 billion shadow network is fighting church-state separation for sure, but they're fighting so many of us right now. And that's the point that I want to make about the $1 billion shadow network.
Yeah, and with this case, they were funding the lawyers, they were funding the briefs, they were funding the media campaigns. Somebody asked kind of some of the specific stuff. And I want to thank Jacqueline and a few others who asked about the history and tradition piece, which we touched on. And it's their version of history and tradition that they're basing these things on, and that is definitely not great. Gabi, Richard was asking real quick for one of our guests, is daily prayer in classrooms like imminent, or is that a precedent that is still holding for now?
For now, that precedent is still sound. The court cited to several of the previous cases about prayer in school and said, this is still good law. And then it just said, this case is different. Said Kennedy, the facts of the Kennedy v. Bremerton case are distinguishable. It's a different set of facts. So those cases still stand. The only cases that are explicitly overturned is Lemon, and the court got rid of the endorsement test. But it did explicitly say, prayer in school cases are still good law. So, a school district can't mandate that all students pray. I'm not going to make any promises on what's to come, but from this opinion, what Coach Kennedy did, or what Justice Gorsuch thinks that Coach Kennedy did or pretends that Coach Kennedy did, is okay. But a classroom teacher cannot stand up and make all of the students in class participate in a prayer.
And Gabby, a follow-up to talking about some of the church state cases, Todd and a few other folks said, you know, as a non-believer or non-believers arguing they have a right to exercise their non-faith, or on the argument that atheism is just another belief system. Is that correct in the way that, you know, the law has been interpreted? Or maybe even that's not the right question if the law isn't being applied correctly anyway? Like, are we moving away from that direction if that was the case?
So the court's been a little bit fuzzy on how do you define religion, and understandably, it's a hard thing to define. How do you create contours about what is a religious belief that gets protection under the Constitution? But I think it goes back to the point we were making earlier when we were talking about what would it look like to bring a case where we represent the Church of Satan? How would the court treat that religious viewpoint? How would the church treat that religious minority? And I think atheists face a similar challenge in that context. So that's not a clear-cut answer because the court hasn't given us one, but I think it's a precarious time to really push the court on that question.
Rachel, we've had a couple of folks asking about, you know, potential AU litigation, you know, moving forward. And I know that we mentioned in our email and press release that we do have some things that we are looking at and moving forward on. Can you talk a little bit about you know, what it is that AU is considering as far as litigation, and especially around protecting, you know, religious minorities as a form of religious freedom?
Yeah, yes, and I made reference to this earlier. Right, we all know, sorry, I'm very tired. I've been doing a lot of media, which is, I know, a good thing, but it's been a very hectic couple of days. You know, there is an intense need to reclaim religious freedom in this country, to get out there and shape the narrative, right? Because it's still the case that, especially with this court reinforcing it, that too many folks are feeling like religious freedom just belongs to, you know, religious extremists or Christians, or really, and, you know, with Reverend Avilesbernal on this call, it's like always a good reminder, right? Not all Christians, just some Christians. And I think part of the work that we have to do is to reclaim religious freedom. And, you know, so part of what we want to do is actually call for a national recommitment to church-state separation as the only way to guarantee religious freedom, and to connect the dots between religious freedom and everything else: reproductive freedom, LGBTQ equality, you know, protecting the climate and science, racial justice, right? And so many other things. So part of doing that, I think part of, you know, reaching folks and getting visibility and helping people awaken to the importance of religious freedom and reclaiming religious freedom is bringing a lawsuit that says we're challenging these abortion bans because they violate my religious freedom. Religious freedom does not just belong to the far-right conservative Christian who says it's against his religious beliefs. What about me as a Jewish woman, where my religion teaches me that I am obligated to have an abortion if my life is at risk? You know, and what about others who share similar belief systems? What about clergy, Doug, who out of their own faith feel that they have to counsel women who come to them, and could be, you know, could be sued by someone across the country with the way the Texas and Oklahoma laws go for a $10,000 bounty, you know, could be hunted down for quote, aiding and abetting a woman who wants to have an abortion just because they're clergy and they're counseling, right? And so I think that what we could do with a lawsuit like this is really muddy the waters about what is really, oh, right, religious freedom belongs to so many of us. And it means that this court, like Gabby said earlier, is hypocritical if you get right down to it. So I think that's really powerful litigation for us, but don't forget about our 20 other cases, please. Right now we've got cases, for example, on behalf of the Rootin' Rams, a Jewish couple that desperately wanted to foster to adopt a special needs kid in Florida, turned away because they're Jewish from a government funded foster care agency. What about Amy Madonna, a Catholic woman in South Carolina, similarly wants to provide a loving home for kids in need, but she's told she can't by an agency funded with her tax dollars because she's Catholic and not evangelical Christian. What about Greg Tucker, a teacher in Colorado who was fired from his job at a Christian school, but he's not, he was like the dean of students or some position like that. Why was he fired? Because he put on an anti-racism assembly and the school is claiming a religious freedom right. That's their defense, to fire him because some white parents complained and he got fired. So we are very busy still with all of the lawsuits, and there are many still that are very worth fighting, but we think that we can also be very strategic and bring some to really expose the hypocrisy of this moment and to seize back the narrative.
We got we have a lot of questions. We're unfortunately not going to get to them. We've been able to combine and get to about 30 plus. So just want to thank everybody for sending these. A couple of questions about litigation things. Sharon, John, a few others. What about media and journalist education? What about working in coalition? I'll actually take these. This is especially the coalition building is a lot of what I do and my colleagues in our policy department. But we work with dozens, if not close to 100 organizations on all different types of policy changes, legislation, both at the state as well as the federal level. And that has been a core part of the work that we've done for a long time. Issues especially like, opposing school vouchers and trying to make sure that, like these litigation cases, that when government funds go to non-government entities to provide public services, that they serve the whole public. And our communications department, and especially as part of this Bremerton, the public education or the media education that we were doing and had to keep doing, I think really made a difference with how the case was covered over the course of the the many months that we were working on it, because it really did start off as just poor Coach Kennedy, who just wanted to pray privately and got fired from his job, all of which were a false narrative to really getting a lot more accurate coverage of this. And I think what we saw also with Carson, with Dobbs, with Bremerton, is that and part of this Shadow Network's goal is to kind of fly these under the radar until they get a ruling. And there's been a lot of waking up, I think, over the past couple of weeks, and there's been a lot of huge amount of media interest in the work that A is doing, even more so than there was before. So I can definitely speak to my colleagues and the work that they're doing there, and the folks in our department. As we're slowly starting to wrap up, I'll let each of our panelists, if you would like to do a 30-second last thought before we talk just the last couple of things folks can do moving forward. Reverend Avilesbernal, if you'd like, is there anything you'd like to add, Gabi or Rachel?
I like to say that the separation of church and state is fundamental to the practice of faith in our country. If we undermine that, we will become a theocracy, and there is no theocracy that has not been cruel, punishing, and awful in the history of faith. So we must work to avoid that. One of the things we're doing is encouraging people to say that it is wonderful for you to spend your day at a protest. Please also spend 2 hours going to vote, because that matters a whole lot as well, and get involved. And lastly, I'd say always ask, where is the justice in this beyond me?
Great, thank you.
Go ahead, Gabi.
Gabi?
I'll just say that I think that it's not at all surprising that two of the major religion cases that the Supreme Court heard this term were about public schools. That's not a coincidence. My mom is a retired public school teacher. I have a lot of friends who are public school teachers. I've heard from a lot of public school teachers and coaches about this case, and they pretty much universally ask me, what was this guy thinking? Because people become public school teachers, they go into public schools because they want to serve students, and they understand that to serve students, they have to make sure that their classroom or their football field or their library is accessible and welcoming. And what Kennedy didn't make it accessible and welcoming to his students. And so I think that tells us that this case is not about religious freedom. If it was about Coach Kennedy's, it's not about Coach Kennedy's religious freedom, because if it was about his religious freedom, he would have accepted the accommodations that the district offered over and over and over again to allow him to pray in private. He didn't. And that's because this case is about so much more. And I think it is representative of a broader attack on public schools. And I've had people on the other side of this case say, well, isn't this a reason why we should just get rid of public schools? And I think we need to take them at their word. I think that we should be taking them at their word when they say things about reproductive justice, and when they say things about guns, and when they say things about getting rid of public education and attacking religious liberty. People have been asking, what are we doing at AU outside of litigation? And I think our policy team, our outreach team is just doing absolutely incredible work, protecting public schools and fighting against vouchers, which are an attack on our public schools. And I'm not going to pretend I'm an expert on that. I will let the experts talk about that. But that is an area that's giving me hope right now, because I think there's a huge attack on public schools starting and coming. And I think that AU is totally in the fight right now to protect public schools.
And Brian, I guess I'll close it out. I know it's 8:30, and I would say most importantly, just don't give up. Don't give up on AU. Please keep supporting us. In fact, tell your friends and family, we need you now more than ever. Genuinely, we have so many great plans, but we need the resources to be able to implement them. And also, don't give up on yourself. Really, I think that's letting the other side win. That's exactly what they're trying to do, right? To stop us from showing up. And I'll just conclude with this beautiful quote that I read to our all staff meeting. Was that possibly just this morning? It was. So here it is. It's from Howard Zinn, who wrote The People's History. And he says, to be hopeful in bad times is not just foolishly romantic. It's based on the fact that human history is a history not only of cruelty, but also compassion, sacrifice, courage, kindness. What we choose to emphasize in this complex history will determine our lives. If we only see the worst, it destroys our capacity to do something. If we remember those times and places, and there are so many where people have behaved magnificently, this gives us the energy to act, and at least the possibility of sending the spinning top of a world in a different direction. And if we do act in however small a way, we don't have to wait for some grand utopian future. The future is an infinite succession of presence. And to live now as we think human beings should live, in defiance of all that is bad around us, is itself a marvelous victory. So thanks for being part of making our country more marvelous, even during rough times.
Thanks, Rachel. And I'll end as I always do, because folks want to know what you can do after this. I'm going to give you 4 things that you can do right after this to support this effort. So the first thing is, if you are not already a donor to Americans United, you can go to au.org/donate and become a monthly donor. Even if it's $5 a month, $10 a month, it all helps out. And we'll send you all of these links tomorrow, along with a copy of the recording. You can also join our AU Action Network, our volunteers who take an extra action once a month or once every other month in support of church-state separation issues. You can go and send a message to your state legislator demanding that they stop funding private school vouchers and instead fully fund public education, which has to serve people of all backgrounds, all abilities, and all beliefs. And finally, AU is on Facebook, it is on Twitter, and it is on Instagram. You can follow us on any or all of those to stay up to date on what it is that we're working on, how you can take action, and things you can share with the folks in your life that you want to become more involved in separating and keeping separate church and state. Thank you all so much for a fantastic night. I know it's tough. We're in this together. Be kind to yourselves, get some rest, and let's rise tomorrow and fight together again. Good night.